Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations related to steno. Be ready for the dictation. Ready? Shri C.B. Yadav, Additional Advocate General, refuting the submissions raised by the learned counsel for the petitioners, supported the order of the state government dated 10th December 2010. Stowe, Learned Advocate General, submitted that the land acquisition proceedings were initiated by the Department of Home for the purposes of construction of police line at Ghaziabad, and the department which had initiated the land acquisition proceedings in the department which is competent to decide an application under section 48 of the Act for release of the land stock. He submits that the state government acts through various departments and the competent authority for deciding an application for release of the land is the Home Department, and thus the state government took a decision on 16th July 2010 that representation is to be decided by the Home Department. Consequently, the Home Department has passed the order stop. It is submitted that allegations raised by the petitioners of bias against the Home Department is without any substance. Stop. The department which had initiated the land acquisition proceeding is the department which is aware of the needs and is competent to decide as to whether the land should be released or not. Stop. Other departments being not aware of the details and requirement of the state are not competent to decide the application under section 48 of the Act for release of the land. Stop. He has also, during the course of submissions, referred to the government order dated 15th September 2006 and 3rd July 2007. Stop. He submits that the state government has already taken a decision by the aforesaid government orders that for release of the land under section 48 of the Act, the department which has acquired the land is a competent department. Stop. A copy of the notification dated 26th March 1981 issued under section 4 read with section 17 of the Act has also been placed before us, and it has been submitted that the said notification has been issued by the state of UP. Stop. It is submitted that Department of Home, being the department which had issued the notification under section 4 of the Act, the decision to release the land has to be taken by the Home Department. Stop para. Replying the submissions of learned counsel for the petitioners regarding hearing, it is submitted that petitioners were given full opportunity by the state government. Stop. The petitioners filed their representation and thereafter filed a reply to the comments, objections of the Home Department and the Senior Superintendent of Police Ghaziabad on 27th April 2007 and 30th April 2007, and were given personal hearing also by the state government. Stop. While deciding the representation, all relevant materials were taken into consideration, and the submission that petitioners were not given due opportunity is incorrect. Stop. He submits that the petitioners have placed on the record before the state government all pleas and raised submissions which have been taken into consideration while deciding the representation. Stop. The plea of the petitioners that principles of natural justice have been violated cannot be accepted. Stop stanza. It is further submitted that the land use of the land in question was not green belt at the relevant time. Stop. In this context, reference of letter of the Ghaziabad Development Authority dated 12th March 2007 filed along with the counter affidavit has been made and relied. Stop. The additional advocate general further submitted that even if the land use at the relevant time was green belt, there is no legal prohibition in acquiring the land. Stop. The restriction is on the use of the land which issue shall arise after the acquisition is made, but the mere fact that land use in the master plan is different from the land use for which the land is being acquired is no prohibition in proceeding with the acquisition of the land. Stop. It is submitted that after the acquisition of the land, the state government can proceed by seeking appropriate amendment in the land use. Stop. In any case, the land use in the master plan 2021 being not green belt, but the state government can very well proceed with the construction of the police line. Stop. Stanza. The petitioner has specifically stated that on oath in paragraph 15 of the writ petition that he had no knowledge of the said FIR or pendency of any criminal case against him. Stop. Further, in para 17 of the writ petition, it has been stated that the petitioner was never arrested in the aforesaid case and he never applied for bail. Stop. The learned counsel for the petitioner has even argued to the extent that the petitioner was contested in the trial court. Stop. As such, when the FIR was not lodged originally, he had no way of knowing about it unless it was investigated. Stop. He was never detained at the police station, never summoned for questioning or arrested for interrogation. There was no way the petitioner could have known about the pendency of a criminal case. Stop. The counsel for the petitioner has further argued that even otherwise, the said criminal case has arisen out of a cricket game being played casually in the locality. Stop. Stanza. The learned standing counsel has filed a counter affidavit and has argued that since the information given in the affidavit was belied in the verification, hence the superintendent of police was justified in cancelling the examination. Stop. On careful examination of the counter affidavit, this court could not find any specific averments or material to prove that the petitioner had knowledge of the pendency of the criminal case against him. Stop. A rejoinder affidavit has also been filed reiterating the allegation and stating therein that there was no material before the superintendent of police, that the affidavit was deliberately filed in order to conceal some material fact or to mislead the authorities into getting extra marks for the purpose. Stop. This being the case, this court comes to the conclusion that on the date when the affidavit was filed, the petitioner was not knowing that the FIR was lodged against him. Stop. Moreover, on the date when the petitioner was sent for training, he already stood exonerated by the trial court on merits. Stop. The order of the trial court has been annexed by the learned counsel for the petitioner, and the operative portion of the order clearly exonerate the petitioner, including others, of the charges under which the trial has connected. Stop. Oblique. Under the circumstances, the court feels that the affidavit filed by the petitioner was genuine and no attempt was made by the petitioner to mislead the authorities. Stop. There was no evidence before the superintendent of police Mainpuri on the basis of which he could unequivocally come to the conclusion that the petitioner has filed the said affidavit with malified intention. Stop. His belief that the petitioner's affidavit was filed deliberately is not based on any cogent material before him, hence the conclusion drawn by him is incorrect. Stop. Apart from this, the court does not have any material to come to the conclusion that the impugned order has been passed after application of mind. Stop. Stanza. Accordingly, this court quashes the orders dated 17/12/2007 and directs the opposite parties to immediately reinstate the petitioner on the post where he was working on the date stop. It has been further pointed out by the learned counsel for the petitioner that this court has had already passed an interim order on 15 to 2008 stop.